Good afternoon, everybody. Thanks for joining us for your lunch hour. We're just going to give people a couple more minutes to trickle in and then we'll get started. Lots to go through today. For those just trickling in, we're just going to give people till about 12:03, very precise, and then we'll get started. All right, just one more minute, then we'll get started. All right, we'll continue to let people trickle in as we go through, but there's lots of information to go through, and I imagine there'll be more than a few questions, and so we'll just go ahead and get started. Thank you for joining us today for the Bill 53 Compassionate Intervention Act webinar. My name is Aileen Burke. I am the director for the nonprofit voluntary sector here at Alberta Council. Been working here for about 4 years now. And for those of you who are not familiar with Alberta Council, we are a law and lobby firm here in Alberta. So it's kind of a really brief overview of the key components of the act we're going to go through. Keep in mind, this piece of legislation is almost 90 pages long, so we did our best to try and condense to as pertinent information as possible, but obviously it is not a full scope document. With that, let's get started. So, Bill 53 is the most sweeping piece of addiction care legislation to date. The idea here is that we are building a process through which we can mandate treatment for folks who are deemed to be a harm to themselves or to others. This is going to repeal and replace the Protection of Children Abusing Drugs Act, or PCHAD, as well. And so this is for adults and minors. The folks who are eligible to apply for a treatment order or assessment order is broad. It includes adult family members, guardians, healthcare professionals, police and peace officers, and individuals who apply to be considered a adult family member as well. We'll also create a new commission. The commission will be made up of a lawyer, a physician, and a public member who will be responsible for reviewing all of the applications and holding hearings. The government is saying that this is the piece of legislation that is going to offer life-saving care amid the overdose crisis, Critics, obviously, it's a mixed bag. Critics warn that it could violate rights and pull funding from other evidence-based resources. So the government also posits that the legislation is needed to facilitate timely intervention and treatment and to support the timely stabilization, assessment, and treatment of individuals while minimizing negative impacts on individual rights and freedoms and respecting the dignity and worth of each individual. This is a common theme that you'll see in the media. Key definitions. There are multiple pages of definitions. We will go through some of them outside of this list throughout the presentation, but these are key terms that everybody needs to be on the same page for to understand what the implications of this act are. So for apprehension order, this is just the right to detain an individual without consent. This is done through commission, and we'll go through this process moving forward. Assessment order and assessment report. So when you have done the apprehension order, a person is able to be detained for up to 72 hours to stabilize, go through medical detox, obviously in a short window of time, and then provide a report to the commission that will be used to evaluate the application. Capacity, a person's ability to understand treatment information and appreciate the consequences of consenting or refusing. When somebody is applying for a treatment order on the individual's behalf, this capacity question is going to be critical in adjudication. Community-based care plan order, you'll see there's a secure plan order and community-based care plan order. We'll go into this more detail throughout the presentation, but this legislation provides the ability to have secure lockdown space treatment orders and the community-based treatment orders, which could be bed-based or not bed-based. And the regulations will provide the direction through which community-based organizations will be designated eligible. Treatment, this will be important to know for when we go through the right to refuse treatment, but it includes anything done for therapeutic, preventative, or other health-related purpose to treat substance use or addiction, including observation, monitoring, assessment, the provision of clinical advice, and the prescribing or administering of a drug as defined in the Pharmacy and Drug Act. Defining harm. When they provided the brief definition for harm under the definition tab, you'll see that they use harm largely to the word harm to define itself. So later in the act, they go through multiple pages that describe in more detail what harm to adults and children looks like, and to themselves and to others. And this is kind of just a high level overview of what that looks like. Harm to self, note, it doesn't have to be all of these components, it's one or more. For the severity of adult substance use or addictions, this includes patterns of severe intoxication or impairment, poorly controlled or unstable medical conditions that are caused, exacerbated, or otherwise related to substance use, and the inability to meet basic needs of daily living. Obviously, you'll have the previous admittance to compassionate intervention facility. This will come into play later on. Negative impacts on key aspects of life, such as health, employment, and relationships, engagement in high-risk behaviors, and then anything else deemed relevant. There are no definitions provided or guidelines provided at this point for what high risk looks like, how we're defining negative impact, that kind of thing. So we'll have to wait for some of the regulations to come forward, but they're quite broad. For harm to others, the same point about the severity of the adult substance use is considered neglect and the inability to care for someone in their care, engagement in harmful behavior towards a person in care, and then negatively impacting community safety. You're going to see a lot of overlap between this one and the harm for children. So age, type of substance use, and substance use history. The severity of the child's substance use or addiction, this one also includes the same components as the adult, patterns of severe intoxication, poorly controlled medical condition, inability to meet basic daily needs. We also have the consideration of previous admittance to PCHAD or compassionate intervention facility, negative impact on key aspects of life such as health, a lot of overlap. One or more interactions with CFS authority in the last 6 months. And then for harm to others, you're looking at the same as, that should say 0.2 above. And then engagement in harmful behaviors that are negatively impacting other persons, including family and friends. You'll note that the word substantial is removed from this definition. And then we've got the same two other relevant factors of impacting community safety and whatever else they deem necessary. So the very first thing this act does is establish a new commission called the Compassionate Intervention Commission. It's composed again of lawyers, physicians, and public members that are appointed by the Lieutenant Governor, which is basically the Premier on advice of the Minister. One of the lawyer members shall be designated the commissioner of the commission, and they will serve as the chair. And then the commission is responsible for receiving, reviewing applications and conducting hearings, non-compliance reviews, and appeals in accordance with the acts and the regulations that will be set out. The commission has the power to dismiss applications, issue and terminate orders, issue, uphold, amend, renew, and terminate care plans, dismiss applications for review, issue discharge orders, grant appeals, and grant leaves of absence. So quite like all of the power is held within this commission. Point of note, the commission may also require any person, organization as defined in PIPA, public body as defined in FOIP, or a custodian as defined in the Health Information Act to provide information to answer questions the commission considers necessary for the determination of a matter before them, and may ask for those folks to attend a hearing and provide evidence at a hearing if they consider it necessary. And this can be done without the consent of the person who's subject of the application. Directors, designated supervisors, designation of facilities and service providers. This act establishes a bunch of new positions that will be further defined in regulations. We're going to talk about regulations here in a few minutes, but it creates a top-down chain of authority. The ministry may pick a statutory director to act as a gatekeeper for all involuntary treatment applications. Now, the act says the word may, but some of the process that we'll see in the next couple slides rely on the statutory director being in this position. So I would suspect that this position will be appointed. Once someone is in the system, so once the application process is started, and there you've got a care plan, physician medical director will steer the clinical side inside the secure facilities, and then designated supervisors will play the same oversight role in the designated community-based programs. And then the minister will have the power, obviously, to decide which hospitals or agencies are allowed to operate as secure compassionate intervention facilities or community providers. And they will have strict incident reporting and monitoring rules to adhere to. For a little bit more context, the medical directors are responsible for overseeing the treatment of clients, establishing binding policies or procedures they consider necessary to provide direction to treatment teams, ensuring reporting requirements are complied with, and they have the power to review a decision of a treatment team and provide direction to that team to consider appropriate treatment. The designated supervisors will fall within every community-based service provider that is deemed by the minister. These community-based service providers must appoint or designate a designated supervisor to oversee compliance with the act in the terms of care plan orders, the preparation and submission of reports by the service provider, and the compliance of each client receiving treatment. The designation of providers, again, this will be up to the minister to dictate. The minister may designate a facility or part of a facility as a compassionate intervention facility and may also designate whether it is for adults or minors. And then community-based service providers will be designated through regulations as either bed-based or non-bed-based community-based service providers. If I'm going too fast, feel free to throw that in the chat and I'll slow down a little. So the very first step of this entire process is to apply, obviously, to go through the application process and have that reviewed. So the Act establishes a legal pathway to apply for a treatment order. Application submission requirements will be established by regulation. You'll see this a lot throughout the Act, and applications will then be submitted to the Commission by the following list of folks who are eligible. So an adult family member of the individual who is subject to the application. This includes parents, guardians, spouse, or adult interdependent partners, child, sibling, grandparent, grandchild, or an adult who's designated by the Commission through application as a family member. So quite broad. A host of healthcare professionals, including a nurse who is a regular member in good standing with the College of Registered Nurses of Alberta, physician regulated through the College of Physicians and Surgeons of Alberta, psychologist who is regulated, member in good standing with the College of Alberta Psychologists, social worker regulated with the Alberta College of Social Workers, paramedics who are regulated and in good standing with Alberta College of Paramedics, addictions counselors, police officers and peace officers. You'll also see noted here. Of note, that has been pointed out a couple times, are RPNs, LPNs, and arguably we think possibly nurse practitioners are not included in this list of folks who are eligible to apply for a treatment order. So we thought that was an interesting point. Application process and execution of orders. This is the ladder for the process through which we establish the treatment order. So the very first step is initial review. This is done by the statutory director who will review the applications to determine eligibility and completeness of applications. If that application is deemed eligible, the statutory director will move that application and forward it to the Commission for review. The next step is a commissioner review, wherein a single lawyer commissioner, so you're not at the panel yet, will review the file and determine if the application for an assessment order demonstrates that the individual is likely to cause harm without intervention. If it does, if they do, the Commission will issue an apprehension order and assessment order. Moving from there, you will get, my bad, I apologize. Thanks, Kathy. Apprehension and transport is the next step after an apprehension order has been issued. If an order is granted, police with peace officer support are authorized to locate the individual and take them into custody for assessment. The person is transported to a designated compassionate intervention center, a secure health facility, something of that nature, for an initial stabilization period. That initial stabilization period is the 72-hour assessment and detox period. During this period of time, there's a multidisciplinary treatment team that immediately provides medical withdrawal management, basic health care, psychosocial assessments, etc. The treatment team will compile information on the case to build a comprehensive picture of the individual's conditions and the risks that they face. The window, that 72-hour window, is meant to stabilize acute intoxication or withdrawal and prepare for the hearing. So the next step is the hearing. Following that 3-day assessment period, the individual has a formal hearing before that 3-member panel of the lawyer, physician, and a member of the public, where the case for compulsory treatment is evaluated. The individual is present, usually, there are exceptions that can be made, and may be accompanied by an advocate or legal counsel, and family members can also attend to provide input. The statutory director that we've mentioned presents the evidence gathered, and the panel determines if the legal criteria for involuntary care continue to be met. Following that, if the application is deemed successful, we then move into the duration and review process. So the maximum initial duration for secure site confinement is 3 months of locked care or 6 months of community care. However, these orders are not one time only. They can be reviewed and renewed. The Act builds in a mandatory review every 6 weeks for any ongoing care plan. And then at each review, the treatment team and possibly the commission will reassess progress and whether the criteria still justify keeping the order in place. Individuals could be subject to successive orders if they repeatedly meet the harm threshold. Finally, there is the ability to appeal these decisions. So the client or their guardian can appeal the commission's decision or the care plan to a higher court or review board. That process will be further established through regulations, but once that appeal decision is made, that decision is final. Care plans. These are individualized court order treatment regimes that kick in after the 72-hour assessment. Once that panel has deemed that intervention is necessary, so they come in two basic forms. One's the secure care plan order, which is the locked inpatient unit where they are under 24-hour supervision. And then you've got the community-based care plan order, just there are two options there, bed-based, non-bed-based. The secure plan's 3 months, community-based 6 months. The community-based care plans could include placement in a community treatment program, residential recovery center, enrollment in day treatment or outpatient counseling, or any other community services that are laid out in the regulations. They do not remain in custody, but they must comply with the treatment regimen. There are allowances for exceptions. So in some cases, a person might start with a secure in-facility stay and then transition to a community-based plan as their condition stabilizes. This is in part why we have those 6-week reviews. The law allows the commission to amend or extend the care plans as needed too. So for example, moving them from secure care to community care or vice versa. If there is a risk of relapse or harm, the risk of harm remains high, they'll just continue to renew the treatment plan. A care plan is created through a multi-step process as well. So this happens after there's a care plan hearing that starts within 72 hours-ish. There's allowances for exception tier 2 of apprehension. The panel issues the care plan order if on balance, this is words from the legislation, on a balance of probabilities, the client is likely to cause harm without intervention. And the proposed plan is to be the least restrictive effective option. Every order must contain identifying details of the client, reasons for the order, and why the chosen setting fits the least restrictive test. The full list of the client's rights, so whether that's like legal counsel, mental health patient advocate, the right to refuse particular treatment, communication, reviews, appeals, etc. And reference to the statutory powers the order confers on the treatment team. And then you've got in there for safeguards and monitoring, you've got the 6-week reviews, you've got progress reports that must be filed 72 hours before each review. Discharge reports are filed whenever the team believes that risk no longer exists. And then there's also non-compliance reviews that if the client absconds or breaches key conditions of their treatment plan, the order can be upheld, amended, renewed, or terminated, etc. So bottom line, the care plan under Bill 53 is the core vehicle for compulsory time-limited addiction treatment. It spells out where and how care will be delivered, what rights that person retains, and how progress is checked. And it creates a escalating review checkpoint process. The right to refuse. This is verbatim from the Act, so forgive the legalese here, and full disclosure, I'm not a lawyer, but if the client has been deemed to have capacity as defined above, a client has the right, which is that definition that we had on slide 3, the right to refuse, except in the following forms of treatment: to be observed, monitored, and assessed by a treatment care, to be provided with clinical advice, and subject to regulations to be administered a Schedule 1 drug within the meaning of the Drug Act. If you recall, the definition of treatment from that slide included everything listed here as well. So notwithstanding the requirements for informed consent and standards of practice of regulated professions, a regulated member of the whatever health professional is part of this process at this point in time, may provide treatment without consent in accordance with this section, including administering a drug as authorized by the commission under this section. If a treatment team determines that a client lacks capacity, a substitute decision maker will be appointed to make treatment decisions on behalf of that client. It was pointed out to me that upon a jurisdictional review completed by the ministry, that every other province in Canada through the Mental Health Act has this process or this ability as well, because they obviously received feedback. There were some concerns about administering medication without client consent, and they had noted that this is a common, for lack of a better way to put that, practice across the country. Obviously, this is controversial, that we've seen it. We've been talking about it for a couple of years now. This is kind of a really high-level overview of some of what the advocates and the critics are saying. They're arguing that it gives families a legal tool when loved ones refuse help and are at imminent risk. It provides a life-saving tool for last resort. Obviously, concerns about civil liberties, undue harm, what happens upon release, recidivism, all that kind of fun stuff, become really pertinent conversation pieces through this. The government argues that this is a Portugal referral-based support. A lot of critics are saying this is not the same model. It could disproportionately impact marginalized Albertans. There's some concerns about the way the definitions are drafted, and the fact that so many pieces of this piece of legislation are delegated through regulations. So to this point, at the end 8 or 9 pages of the Act, there are 2 sections for regulations that are delegated. One is delegated regulations through the Lieutenant Governor, which will come to the Ledge. They will be debated on and passed through the normal process therein. However, there are 7 pages of delegated regulation power authority given to the minister to establish a whole host of policies and procedures and the way this program is really going to be fleshed out, that don't have to come to the Ledge. And so part of what we all have to watch for those of us who are interested and are going to be impacted, is what those regulations are going to look like and how you want those regulations to look like, what they should include, what safeguards should be included, et cetera, et cetera. And so while we have the legal framework, a very broad legal framework, a lot of the nuts and bolts of how this act is really going to be rolled out are going to be found in those 7 pages of delegated regulation authority making. That's in the biggest nutshell possible, the very high level overview of compassionate intervention. I see there's a couple questions in here, but it looks like Erin's answering them. Kathy pointed out to me, thank you for correcting my ignorance here, but that nurse practitioners are included because I am an idiot and they are regulated by the College of Registered Nurses of Adult of, College of Registered Nurses of Alberta. So we are just missing, not just, but we're missing RPNs and LPNs. Lauren asked, is there any requirement that the 3-member panel have at least one Indigenous member, particularly if the individual? No, it does not state that. The act does include a component, a very special piece that I'll pull up and read to you because it's just like a one statement thing. You being like this. So pulling it up in the legislation. There is a 1 or 2 line sentence in here that talks about allowances for culturally sensitive community-based programming and partnership with Indigenous nations. That I'm just pulling up, but it doesn't go into a whole lot of details about that either. And so again, these are some of the conversations you're probably going to want to think about when you are looking at regulations, or if you're engaging with government to talk about some of these things. Those are questions to bring forward there. Anybody else have any questions as I continue to scroll through this ridiculousness? Oh, yeah. Okay, here we go. Page 75, 1 line only. Agreement with First Nations and Métis. The minister may enter into an agreement with any person, including a band, within the meaning of the Indian Act, in which a power, duty, or function under this act, except that of the minister, may be exercised in accordance with the agreement. It's kind of a catch-all statement. They have the ability to enter into an agreement. What that looks like will depend. There are initial legal challenges to PCHAD legislation for youth when first enacted, but it did not result in the suspension of PCHAD. Yeah, it's a good point, Brian. Yes, and this will replace PCHAD. We already know this is going to be legally challenged. People have already come out and said they will be just challenging it. Organizations have come out on civil liberties. It's a little bit more far-reaching than PCHAD. Obviously, it includes adults too, but part of the struggle is in the definition of ability to refuse treatment. We're not really sure what they're allowed to refuse based on this definition, right? Like that's a pretty expansive list. And so that's part of where it has been speculated that some of the legal challenges might come through, though. Obviously, there's the argument of civil liberties. The other note is that from my understanding, and again, not an expert, PCHAD was limited to, I think, 15 days of confinement, and this extends it to 3 months or 6 months of community-based. And so it's far broader. Are there any limitations to potential abusing of the system? We'll see more of that in the regulations. They do put statements in the act about not allowing frivolous applications and vindictive applications. That'll largely have to be determined by the panel and how those applications are put forward. It's going to be a little bit discretionary. And that's part of the critics' response to this too, is that a lot of this is subjective or discretionary, and we're not really sure how it's going to be interpreted. So we're hoping that the regulations will provide a little bit more boundaries around what this will look like. Anybody else have any questions? So if not, I'll give you all back half your lunch hour. Right. Well, seeing no questions, my contact information, any tip for the scope to be. Shay, I don't think you finished your a mom and a team. I don't think I understand your question, Shay. Can be apprehended at the same time. Arguably, yes, it'll depend on what the applications that are put for. You'll have to have two separate applications, one for each individual. And so it'll be up to the panel and the commission to review that and determine the appropriate course of action there. Next steps that should be taking if we are not in agreement with this legislation. Next steps you should be taking if you're not in agreement with this legislation. Okay, there's a few things that you can look at. One, you're gonna want to influence regulations. So you're gonna want to try and find a collaborative approach to talking with Mental Health and Addictions Ministry to try and influence regulations. Let's be clear. This legislation is going to pass. It will pass the House. They have a majority. It will pass. Any legal challenge that may or may not occur will take a couple years. And so by the time we get to that point, this will already be in place. So your best bet at this point is to try and influence how the regulations are going to be crafted. There are a lot of different avenues through which you can look at that. I would say there's safety in numbers, there's power in numbers. So if you have supporters behind you, then leverage that. Squeaky wheel gets the grease, right? And so I would approach it that way. I also proceed with caution. Try as best I know if you're not in support of the legislation, it is difficult to find collaborative ways to work to influence legislation, but that is going to be your biggest battle right now. You are going to want to find a way to do this collaboratively. How are the applications submitted? To be determined by regulations. They have not established that. From what I could glean from the act, there will be a process through which the person who is applying on behalf of somebody else will have to watch some kind of video and then submit an application, possibly online, but we don't even know what the application looks like or what the contents of the application will include, because those will be established through regulation. The apprehension part of this bill, will it only be RCMP or peace officer? Yeah, police and peace officers. Says police, and then it says in brackets, with the support of peace officers. And so it's this will be broad, it'll be reaching, it'll be any of the above. Anybody else? I asked Caitlin asked, do you know if they have a timeline for the release of those regulations with the finer details? I asked this question myself. There is no set timeline at this point. We suspect, this is purely speculation, that regulations will be crafted probably over the summer when they're not sitting in session and then rolled out in the fall. Nope, you sure are not. That is a very pertinent question, so thank you for asking it. Okay, well, if there are no other questions, my contact information's on the screen, so feel free to follow up should anything come to mind later on down the road. Appreciate you giving us your lunch hour. Thank you for joining us today, and I hope you have a great, oh, hold on. Sorry, a couple other quick. Is there any plan for OD prevention post-detainment? There's a discharge plan process through which some of that might be contained in. The discharge process will, there's a report, it will include treatment orders and recommendations and that kind of thing. There's also a caveat that's provided that if an individual is ready to be discharged, but they wish to stay in care and they have nowhere else to go to pending space availability, they might be allowed to stay in those facilities. And so some of those details will come out in regulations as well, but specifically for OD prevention, there is largely a belief that this won't be a huge concern because they'll have gone through this process and they won't be at harm to self or others anymore. And so the idea is that once they're released, they won't be using anymore. That's part of the premise. 7 pages of, yeah, I can definitely go through some of that. So there was a question about going through the high level overview of the regulations. So on pages from page 76 forward of the Act, there are 2 sets of regulation powers. One is regulations that are established by the Lieutenant Governor, and that's about 1 page. They provide some more parameters around what regulations can be made, and they're pretty limited, and what safeguards are put in place. So like if a regulation is made under the Lieutenant Governor, it has to be repealed 5 years after the regulation comes into force. Doesn't like there's some limitations and some safeguards around there. For the ministerial regulations, just says that they may make regulations talking about quite literally everything from prescribing certifications and programs for the program, how guardians are involved, the powers and functions of all of those new positions that we spoke about, oversight of the program, designation of community-based service providers, whether that's bed-based or non-bed-based. That's talking about rules and procedures, the conducts of behavior from the commission and the treatment teams and some of those folks that are involved in this process. Everything to do with the application process and what has to be included in the applications themselves, how applications are reviewed, dismissed, discharged, appeals, that kind of fun stuff. What kind of records are needed to be accessed? What can be prescribed? What can be included in a care plan? How hearings are conducted? And so very like it again, it's 7 pages. It's quite expansive. I think it goes all the way up to triple E in terms of like what's detailed. So those are the things you're going to want to look for. This will be the nuts and bolts of everything. What else do we have? How will it work for rural communities that have limited access to treatment or health professionals? Any idea how they will be brought to treatment centers? If that is RCMP, then that takes our RCMP off the street for a whole shift depending on distance. Yeah, really important question. Part of this is through the budget, 2025, there was a lot of money, I can't remember the exact sum off the top of my head, that were designated to build two new compassionate intervention facilities, one in Edmonton and one in Calgary, I believe. They are supposed to hold, I think it's about 150 people each. Those will be some of the, I think those are meant to be operational next year. So that'll be where some of those folks will be held in treatment. For the ones that don't meet the threshold for secure care plans, but for community-based care plans, that will be an entirely different conversation for how they will access treatment or health professionals. And I would suspect that a lot of this will be then built into online platforms. So you've got the VOPD program, we've got online counseling, that kind of thing. It's where I suspect that will go. This will be a point of advocacy for your rural communities, especially that if you are involved in some of this process, you're probably going to want to have some influence over those regulations and how those community-based providers are designated. For the policing for transportation, yeah, I don't know that there's an answer for that. I think that's going to be an advocacy point, something to raise. Honestly, some of these details are probably pieces that have vaguely been thought of because they haven't built how the program will be completely rolled out yet. So take these questions and advocate to the minister and your local MLAs and all that fun stuff to try and get some more details about how that's going to look. Any sense on how they're going to manage the people who want voluntary care and can't get any? Part of the ministry's work over the past few years has been to try and increase access to voluntary treatment care. And so that's through initiatives like VOPD, the recovery communities, more treatment beds, etc. The argument at this point in time is that there's lots of space for those who are looking for voluntary treatment, maybe not through counseling, but there's space available and treatment is accessible. And so there's nothing to manage, I guess, from that kind of standpoint. Now, obviously, there's some debate as to how accurate those statements might be, but that's kind of where we're at with that. 5 to 9 hours away in the north, yeah. Creta, you're absolutely correct. It is a concern, especially when police resources are already limited. Transportation and distances will be a huge hindrance. And there are a couple provisions in the act that allow for one police officer to kind of transfer the person to another police officer so they can do this like chain of transportation. But again, that'll be detailed further in the regulations. And how will people be returned to their home communities? I don't have a clue. I don't know the answer to that question. They don't really detail that either. Again, this will probably be part of the discharge plan and the discharge report. I imagine some of those details will be included in there. Some of the things that will hopefully be included in regulations for how that will be managed, but the bill itself does not detail that kind of question. Would advocacy alongside RCMP be possible to engage federal pressure? This is provincial jurisdiction. And given the contentious relationship and the tensions between the federal and provincial governments as is, I don't know that you'll get a whole lot of traction. I think advocacy alongside RCMP, you could do on a provincial level. If you have sheriffs, if you have peace officers, leverage those relationships as well. But I don't know. It's provincial jurisdiction. I don't think the feds will be able to assert any kind of pressure to change this. And we also have Bill 18, the Sovereignty Act, and whatever other legislative mechanisms that have been passed in a few years to try and curb federal oversight or ever overstep. That'll be a difficult battle to go that route. In the urban-ish municipal RCMP, no city police. Yeah. Federal conservatives have proposed some kind of involuntary treatment if elected. Correct. Yeah. If the CPC are elected, they have come out in support of a lot of what is seen in the Compassionate Intervention Act. I have not seen the LPC come out in support of that, but there is a definite divide between the two political camps about how to approach this. Obviously, if CPC get elected, it will not matter if you advocate to them because they are in support of this legislation. LPC hasn't come out and said yay or nay directly. But again, it's still provincial jurisdiction, and we have passed legislation in Alberta that, like the notwithstanding clause and such, that would limit any kind of provincial federal influence on the passing of this legislation. Cannot get over the fact that this is called compassionate. Yeah. And okay, so Jane, yes, cannot get over the fact that this is called compassion. I'm still stunned. Strength in numbers, citizens need to come together to advocate the best we can, but it's going to be an uphill battle. It is a difficult piece of legislation. It is hugely controversial. There are definitely things to be concerned about. As somebody once said to me recently, just I think last week when this was tabled, what are you so upset about? The government simply trying to save people's lives. That's their perspective. And so this is where you see this polarized divide of how we want to approach this. Josh, to your point about a charter breach challenge, we 100% expect that there will be a charter challenge, but this will take years. And by that point in time, a bunch of this programming will be enacted. And so that'll be fine once we figure out what the courts are going to do, and that'll be where the feds get involved-ish from a legal standpoint, because it'll be Canada challenge. But in the meantime, this will be provincial jurisdiction. It will pass before May long weekend. Like that's when session ends. And we have to do what we can to try and, for those of you who are not in support of it, mitigate harm through the regulations. For those who are in support of it, to try and ensure that the regulations are reflective of what you feel like this program is going to accomplish in community. Interesting that Minister Ellis stated in the legislature that RCMP have 20% vacancies and is willing to pass this bill, putting more stress on RCMP. Part of this is there's conflict between RCMP and the province too. And we just introduced, I don't know what stage of reading it's at right now, but recently just introduced the companion piece to the RCMP of like the Alberta Police Force through the sheriffs and stuff. And so part of that is going to is playing into that narrative too, right? And so this piece of legislation crosses over, from my list, I think 1, 2, 3, 4, 5, 6, at least 7 or 8 other pieces of legislation. It is complicated, it is broad, and it's vague. So there are a lot of questions that we don't have answers to. 50,000 people who have died from drugs also consume exorbitant amount of the healthcare budget, which reduces the efficiency of the healthcare system. For sure, that's part of the argument the government's making, that the folks who have severe substance use disorder are taking up valuable spaces in healthcare facilities, using excessive justice resources, etc., which puts a strain on budgets. That is part of the justification to this legislation. Does not give you much time. Yeah, there's not a lot of time. Again, raise your concerns. It's still being deliberated in the ledge right now. Session ends May 15th, which by that point in time, I suspect that this bill will have passed by then. You will have a few months to discuss regulations and try to get some influence there, but it is a tight turnaround. So, thank you, everybody, for joining us. I do appreciate it. Please feel free to reach out if you have any questions or concerns. Happy to have a conversation with anybody. I hope you have a great rest of your week.